Thank you for the opportunity to addressing you on behalf of 5,795 victims. Your Honor, I would like to insist on our request made by my colleague Paul Bradfield in terms of including sexual enslavement. Your Honor, legal characterization is important for victims. Invisibility is something that hurts victims. And I think the question is very simple. Can you enslave somebody without committing sexual acts? I think the answer is yes, you can. And if you answer that in the positive, then it's clear that enslavement does not cover all the interests that the drafters and the international community wants to protect by charging and by confirming charges eventually of sexual enslavement. This is important for victims because, and it always surprises me how lawyers that have no contact with victims believe that their only interest is money. When we go to the communities, they tell the court what happened to us. Of course they want reparations, and it's a right. There's nothing bad about reparations, but it's not the only thing they want. So when they say, tell what happened to us, it's not just the facts that matter. It's also how a high court like this one characterizes what happened to them. Therefore, the lack of the charge of sexual enslavement is saying that that didn't happen really, not in the legal point of view. I understand that in the facts they are there, but tribunals have the competence of the competence, so you have the power to characterize the facts. It's within your domain as what is really in the legal world. Criminal law plays a fundamental role in reaffirming norms and values that we hold dear to us. So that's why we must insist on the request made by my distinguished colleague, Paul Bradfield. With regards to the submissions of the defense, Madam President, Your Honors, I must be honest. I find it creative. I found it interesting, but I also found it with no legal basis. What my learned friend is asking you to do is to eliminate Article 61(2)(b). The natural consequence of holding the procedures, because there might be, he might appear, there might be expensive proceedings, there might be violations of rights or everything he said. Well, then why did the framers put the possibility of in absentia charges? And it's that, I think, not only smart, not only creative, interesting, but also smart, because he's trying to relitigate what he already lost. The appeals chamber and the decision, confirming the decision to move forward in the absentia confirmation of charges in paragraph 75, take care of the concerns my learned friend presents to you about the rights that he can exercise when he shows up. Let's not forget that. It's his determination, his will to be absent. Madam President, my learned friends from the defense are right that the people that are victims of the crimes of Joseph Coyne are much more than 5,795. None of the lawyers who represent those people, and I must say, because I like to say this every time, these are each individual people. They're not victims. They're not a number. They are actual people. And we know that the crimes that Mr. Coyne committed with his co-perpetrators affected much more people than 5,795. And what's more important, the people that we represent know this. They understand that they are a very small portion of those affected by the crimes that my learned friends have to represent the suspect. But in no way can this be understood as if they don't want a broader picture to be shown in this courtroom. You are well aware, Madam President, Your Honors, that the scope, the geographical scope of this case is much broader than the one that was brought up with Dominic Ongwen. So it would be a little bit strange that because there's a few number of people participating, then you want to shut the first step in the road to justice. It doesn't make sense that this would be in the interest of ending impunity, which is the purpose of the Rome Statute, a canon of interpretation that must illuminate all of your reasoning. And, Your Honors, we haven't met at least I haven't met the Minister of Justice, nor the President, nor the most powerful leaders of Uganda. No. We've met those who we represent, simple people in the communities suffering the consequences of the crimes of Mr. Coyne. And it puzzles me because what they say is that they want justice. They want you to confirm these charges because they know, because they lived through it, that there is more than substantial grounds to believe that Joseph Coyne is responsible for the crimes that he's being charged today. And they understand. It also always puzzles me why there's this paternalistic view among victims in the communities that, they'll get confused. No, they understand. My colleagues that went to the communities told them, look, we can't move on if Joseph Coyne doesn't appear. They know this. Why is it that they believe that people are confused? They might be frustrated, yes, of course. But confused, they know. We've told them. We've done our job. My colleagues have done their job. And like I say, victims want truth. And it's in their interest, and it's their right. As Judge Antonio Cansado Trinidad, in paragraph 32 of his concurring vote in Bamaka versus Guatemala back in 2000, said the right to truth is intertwined with the realization of justice and guarantee of non-repetition. So it's an individual right of those who we represent, their families. But not only is it an individual right, it's also a collective right, because by sanctioning these crimes, you are trying at least to affirm a guarantee of non-repetition and to end impunity for such crimes. But not only the international community has an interest in justice. And this is why I was particularly surprised, and we talked among ourselves in the team, when we heard that the community leaders were not interested in justice, that they didn't like the ICC, but they found it self-interested. On 19th of May 2016, my friend and colleague Joseph Manova, myself, Ms. Jane Odong, may she rest in peace, a former lawyer working for OPCV, and Paul Bradfield. He was in the prosecutor's office that time. We went to Lukodi to commemorate the massacre in Lukodi. And that's not interesting to you, but what might be interesting to your honors is that in that commemoration, who spoke was the paramount Acholi leader, Mr. Wuwak Achana. You see, that's why Joseph corrects me rightly. And he said, and this is very interesting, Your Honor, well, I find it interesting, that he said that he personally had a personal gratitude towards Joseph Coyne and Dominic Ongwen because there was a plot to assassinate them in one of the meetings that they had in the peace process, and that Joseph Coyne and Dominic Ongwen spared his life. But despite that, he said that just as if Dominic Ongwen has committed crimes, he must face the proceedings. And he also said, Acholi land has soaked up the blood of innocent people and called upon all the people to support the ICC trial. So we have victims that support these proceedings. We have the paramount chief of the Acholi land. And also, we have a decision by the Supreme Court of Uganda that mentioned, it's in the, I'm really going to pronounce this bad, KYAGULANYI case before the Supreme Court on an appeal from the Constitutional Court about Mr. Kowelo was saying that he had been discriminated because the amnesty had not been granted to him. And the Supreme Court determined that the person who commits such crimes may be eligible for amnesty for the act of rebellion or waging a war on Uganda. But he is not, in my view, entitled to amnesty for grave crimes he may have committed. So, even the amnesty law enacted in Uganda would not grant amnesty to such grave crimes. But furthermore, Your Honors, Article 21, number 3 is clear that the application and interpretation of law pursuant to this article must be consistent with international recognized human rights. Your Honor, I thought I was going to speak tomorrow, and this might be absolutely irrelevant to you, but tomorrow is the 51 year since the military coup in Chile. I come from Chile. So we know about this discussion of truth and reconciliation, transitional justice, And it always surprises me that the powerful are concerned about reconciliation, but they never ask the victims. The victims, the ones that suffered the consequences of the crimes, the ones that were raped, that were killed, that were disappeared, they have no voice in this, it seems. It's among the powerful that decide. Fortunately, the Inter-American Court of Human Rights has dealt, because of this long-standing practice of our leaders to wanting to grant amnesty laws for grave human rights violations, has abundant case law talking about the incompatibility of human rights standards with amnesty laws. Just to quote some cases, Barrios Alto versus Peru, Almonacid versus Chile, Gelman versus Uruguay. So this regional body has again and again said that you can't establish statute of limitations, amnesty laws against these grave breaches of crimes. And a similar reasoning was done by the ICTY in Furunziga, in paragraph 155, where they talk about the prohibition of torture and how it would be strange that if you have a prohibition of torture, then you would give amnesty for torture afterwards to public officials. Your Honors, even Human Rights Court, which is more cautious on establishing a blunt prohibition on amnesty laws, in the case Margus versus Croatia, that's my Spanish kicking in paragraph 139 states, in the present case, the applicant was granted amnesty for acts which amounted to grave breaches of human rights, such as intentional killing of civilians, inflicting grave bodily harm on child, and the country court's reason referred to the applicant military officer. A growing tendency in international law is to see such amnesties as unacceptable because they are incompatible with the unanimously recognized obligation of states to prosecute and punish grave breaches of fundamental human rights. Even if we were to accept that amnesties are possible where there are some particular circumstances, such as reconciliation process and or form of compensation for victims, the amnesty granted to the applicant in the instant case would still be not acceptable, since there is nothing to indicate that were any of these circumstances in the case. Your Honors, I convey to you that that is exactly the case in Uganda. There is a policy on transitional justice, but there's no truth commission. There's no real reparation process going on. There's nothing similar to a transitional justice process occurring in Uganda. It is for all these reasons, Your Honor, that victims request that you dismiss the allegations from the defense and confirm the charges. We believe that the prosecutor has met the standard of substantial grounds to believe, and victims don't want this to be interrupted. There is still a misunderstanding of what victims want. Staying the proceedings, it's not, Your Honor, that they wanted to be heard or they wanted someone to read in this court. They follow these proceedings in Uganda, and they follow them massively. When they are screening, thousands of people show up. It's because they're interested that an official body, an international body, the body created to end impunity in 1998, delivers justice. This is the first step. So this is why we ask for the confirmation of charges. Thank you, Your Honor.